Queen Mary's University, London, and is currently practicing as a senior associate solicitor from a leading law firm in London. Zahra, I'll let you take it from here.
Thank you very much, Zinadanti, for the very kind introduction. Thank you. Jazakumullah khair.
Zahra, can I take your permission to do a link for your lecture in case somebody asks for it?
Of course, you may.
And I'll take your permission to give it out.
Of course. Anytime.
So we'll do a link for Zahra's lecture in case anybody wants to ask her questions later or listen to it later. Thank you.
أعوذ بالله السميع العليم من الشيطان اللعين الرجيم. بسم الله الرحمن الرحيم. رب اشرح لي صدري ويسر لي أمري واحلل عقدة من لساني يفقه قولي. My dearest elders, mothers and sisters, Assalamu alaikum jami'an wa rahmatullahi wa barakatuh. I hope and pray that this finds each and every single one of you and your families and your loved ones safe and well, inshallah. Zinat Aunty has asked me to give you a talk today on two very important issues that have become even more pressing and even more important in light of the pandemic. When we're sadly seeing people falling unwell, we're seeing people sadly passing away. And in this, there is a lesson for us. As in everything that Allah subhanahu wa ta'ala sends us, there is a lesson. And Allah is teaching us that we have to be ready to meet Him at any moment. We could be summoned to meet Allah subhanahu wa ta'ala at any moment, and we have to be ready. And part of those preparations for death is ensuring that we have our wills, our wasiyah ready and written. Now, many of you will have heard me give this presentation before. I've given it several times. And usually I've done the presentation, I've done 1 hour for wills and 1 hour for powers of attorney. Today, I have 25 minutes to do both of them. So I will be going quite quickly and I will only be covering the main points. If you have any questions, please come and see me afterwards. I believe, as Gulzar Aunty said, this presentation is being recorded. There are other links on YouTube to previous presentations that I have done. So if you would like to watch the longer version, the more detailed version, please let Zinat Aunty know and I will make the link available to her, inshallah. Now, these topics are very complicated. And although I am a fluent Gujarati speaker, it is quite difficult to explain these concepts in Gujarati. So I will try if I can, but if I speak in English most of the time, please forgive me. So with that, if you could bear with me one moment while I share my screen and the slides that I've got there. Okay, so. Can I just have a nod from Gulzar Aunty to see if you can see my slides? Yeah? Okay.
Perfectly, yes.
Yeah, thank you. Okay. So to start off with wills, and this is the first part of the presentation that we're going to be addressing, we need to understand what is a will. What does it do? Now, a will is a document that deals with the distribution of our estate. I wilni andar apre lakhe ka apro mal apri je ganimat che who it goes to, where it goes and who receives it. What our estate is, we will come to in a second, because not everything we have is part of our estate. So our will deals with the distribution of what we call our estate. The second point to remember is that the will only becomes effective when we die. The will does not take effect until the point of our death. And lastly, the will can be changed at any time up until the point that we die. So we can make a will, we can change it. If the family circumstances change, we can amend the will at any point up until the time that we die. But we have to have what we call the relevant capacity. We have to understand suthaite. If we have started to suffer from illnesses and diseases that affect our mental abilities, then we have passed the point of amending our will or even creating a will. So it's very important that a will is written as soon as possible, before old age reaches us, before those illnesses, before those disabilities start coming in that affect our ability to make these decisions. It's important that the will is written as early as possible. So why do we need a will? Now, first and foremost, all of us sitting here, we're Muslims. Allah subhanahu wa ta'ala in the Quran directs us that we have to make a wasiyah to dispose of our wealth. And on the slide, I've put in there the various verses of the Quran most particularly in Surah Al-Baqarah and Surah Al-Nisa, that deal with the wasiyah, that deal with the will in Islamic thought. I'm not going to dwell too much on this because I'm going to focus more on the legal side of things. But if you have any questions on the Islamic side, please speak to me afterwards. So the first reason we need a will is because our religion tells us to. The second reason is the will gives us control. If we die in this country without making a will, the law steps in and decides which of our family members receive our assets. Now that may be very different to what we wanted to do. So the will gives us control over that process. We can choose where our assets go. We can choose who is the executor. The executor is the person that we appoint in the will to make sure that our wishes are fulfilled. So we can appoint trusted individuals, people that we trust to do the right thing to carry out our wishes. So this process gives us control. The third reason is that it minimizes, it reduces inheritance tax that may be due on our death. Some of you may know that when somebody in the UK passes away, if the value of their estate is above a certain amount, they will have to pay tax on their estate. We'll come to that a little bit later on, but if you have a properly drafted will, it can reduce the amount of tax that you have to pay or your estate has to pay when you pass away. And lastly, dealing with your estate. When somebody passes away, dealing with their estate is much quicker and much easier where there is a will in place. If you don't have a will, there are additional hoops, as we would say, matakuti to go through if you don't have a will. So having a will makes the process simpler and easier for everybody after you have passed away. So I said at the beginning that the will deals with your estate. Now, what is your estate? The estate is everything that we own at the time that we die. So that includes any cash that we have in our bank accounts. That includes our personal possessions. So things like clothes, jewelry, the contents of our houses. It includes property that we may own. So the house that we live in, some people may have rental properties, investment properties. That's part of the estate. Any investments, any ISAs, for example, that people have, that is part of the estate. And if you are living in the UK, any asset that you have in different countries is also part of your estate. And all of these things have to be catered for within the will itself. Now, there are a few important things that are not in the estate. So these items cannot be covered by the will. So the first thing is any assets that you hold with somebody else. So for example, we may hold property with our spouses. We may hold a bank account with somebody else. If we pass away, that property or that bank account passes automatically to the other person. It doesn't come under the will because of the way that we hold the asset. So anything that is held jointly is generally not part of your estate. Any, for example, life insurance policy that you have nominated somebody else to receive. So for example, if I pass away, a certain individual gets a sum of money under my life policy. That life policy, because I have nominated it for somebody else, that is not part of my estate. It goes directly to the person who I have nominated. So my will does not cover that life policy. And the last thing is private pensions. Some of you may be in receipt of private pensions. You may have been working for a part of your life with companies, and you may have set up a private pension scheme. The pension provider allows you to nominate who receives any pension on your passing. So this, because you are nominating somebody, this does not form part of the will. So these are the three main assets that are not covered by the will. Everything on the previous slide, cash, personal possessions, property, investments, all of this is covered by the will, but these three, jointly held assets, insurance policies, and private pensions, are not covered by the will. So what should I include in my will? When I'm sitting down to think about what I need to put in my will, what do I need to put in there? So as Muslims, for example, it is very important for us that our burial is conducted in accordance with the rulings of our marja, and within the rulings and within the confines of Islam. So one of the things that we can put in the will is burial wishes. If we have any specific requests with regards to our funeral, with regards to our burial, with regards to the ceremonies that take place after we have died, we can include that within the will. The second thing that we can include within the will is to choose who our executors will be. Now, the executor in Arabic is termed the wasi. You know how we say, for example, Imam Ali was the wasi of the Prophet. Imam Ali is wasi Rasulullah. Imam Ali alayhi salam was the executor of the will of the Prophet. Imam Ali was responsible for making sure that the Prophet's wishes after his death were carried out. So the will gives me the opportunity to choose my executors, people that I trust, to ensure that the wishes that I have put in my will are carried out exactly in the way that I have intended. The third thing that we could put in there is specific gifts of cash or property. Now, some people may wish to leave payments to charity for sadaqah jariyah. I have had even people coming to me saying they wish to leave their properties when they pass away to charity. So this is an opportunity for you to manifest that intention in the will itself. Now, all of us will have gone through our life at some point, and we will have qaza, outstanding obligations, with regards to our salah, with regards to our sawm, with regards to our khums and our zakat. The will gives us an opportunity to put in something about making sure those religious obligations that we have not fulfilled in our lifetime are fulfilled on our death. So we can allow for payments to be made for qaza namaz, qaza salah, any that we may have missed during our life. We can then stipulate what happens to the rest of our estate once any debts, any qarza we have is paid off, if there is any tax to pay, once that has been paid, and once any funeral expenses have been paid, we can then sit out and set out how we want our will to be distributed. Now, as we know, Islam or the Sharia gives us 1/3 of our estate to do it as we wish, and 2/3 we have to distribute in accordance with the Sharia. That is another issue for another day. I'm not going to get into the complexities of that today. But the will gives us an opportunity to set out how, once all of these things have been settled, how we want our estate to be divided between our family members. So one thing that is very important is that just telling somebody what my wishes are after my death is not enough to make my will valid. In Islam, an oral declaration of my wishes, an oral conversation with somebody is sufficient. But under the law of this country in which we live, in order for a will to be valid, it has to be in a certain format. And if that format is not met, then the will is not valid and you are treated as having died without a will. So the very first, basic point that we need to make is that the person making the will has to be an adult, has to be over the age of 18. The second part, which is very important, is that when you make the will, you have to have what is called mental capacity. So that means you have to understand what the will is, what the purpose of the will is, and you have to understand the effect of what it is that you are writing in the will. If you're not able to understand those two things, then you are not deemed to have mental capacity and your will could be challenged. So for example, if I'm seeing somebody extremely elderly who is suffering from, dementia or Parkinson's or Alzheimer's, very often I will need to speak to their doctor, to their GP, to see if they understand what the purpose of the will is, and I would need to have a conversation with them and with their GP together to make sure that they have the capacity to understand the will, otherwise the will could be challenged. It is really important that the will must be your will. You should not come under pressure from anyone else to make a will in a particular way. And we see this all the time. We see, for example, children coming into our offices with their parents, and they want their parents to make a will in a particular way that benefits them greater. The will has to be your will, which is why when we speak to people, we make it a point to speak to them alone, to make sure that we can have a proper conversation with them to understand what their wishes really, really are. I've put in red here the most important parts, that the will must be in writing and it must be signed. If it is not in writing, it is not a valid will. And the other point that I want to make is that there must be 2 adult witnesses to the will. So 2 people must witness your will. Now, anybody who is inheriting under your will, a spouse of that person or a child of that person, they cannot act as a witness for you. Otherwise, they will lose their entitlement under the will. So the people that act as your witnesses must be people that are completely independent from you. So in most cases, people ask their neighbors or their friends, to act as their witnesses. Usually people within the family can cause problems. So it is best not to have anybody connected to you that is your witness. It is best to have completely independent people. And if these steps are followed, you will then have a valid will. Now, what happens if I die in this country without a will? I may have orally expressed my wishes to my family, but what does that mean in the eyes of the law? So in the eyes of the law, if I die without a will, I am treated as dying what's known as intestate. That means dying without a will. Now, the law sets out special rules as to who inherits my estate if I die without a will. Now, there's a problem here because if the law steps in and decides who takes my estate, that could be very different to what I intended, which is why, as I said at the beginning, the will gives me control. It gives me the ability to decide who receives what. If I don't make a will and I die without a will, then legally the law steps in and tells me that certain family members get certain assets of mine, and I may not want that. The other problem also is that these rules are not in line with the Sharia. They completely differ from the Sharia. So if you die without a will, not only do you have no control over who gets your assets, but they're divided in a way that is not in accordance with the Sharia. So you've not fulfilled your religious obligation either. So if I die without a will, what does the law say? There are 3 different scenarios, and the scenarios depend on which of my family members survives me. So if I am married and I have a spouse, but I have no children, my spouse gets everything. If I have a spouse and I have children, my spouse gets a portion of the estate and my children get a portion of the estate. And if I die and I have no spouse and I have no children, then the estate will go to wider family members. They will start off by looking at parents. If you don't have parents, they will look at brothers and sisters. If you don't have brothers and sisters, they will look to aunts and uncles and then cousins. And if you do not have any family members, and sadly we come across this quite often, if you die without any blood family members, your estate goes to the crown. It goes to the government. And the government can then do what they want with your estate. So to avoid all of this happening, it is best to put in place a document that, as I said at the beginning, gives you control. This whole process is about giving you control over everything that you have worked so hard for in your life, to make sure it goes to the right people in accordance with the Sharia. I very, very briefly want to mention inheritance tax, because this is something that people don't really understand, and we're not very aware of this, particularly within our communities. We're well aware of the importance of making a will, but we don't necessarily concentrate on this, which is part of that. So when somebody dies, if the value of their estate is above a certain amount, they have to pay, or the estate has to pay tax on that. Now, anything that passes to a spouse or to a charity is free of tax. There is exemptions for spouses and exemptions for charities. But in every other case, there is usually tax to pay. And I've set out here on the slide very briefly the thresholds that exist currently. So if you're a single individual with no children, you have an allowance of £325,000. The first £325,000 worth of your estate is free of tax. If you are married, but you don't have any children, your allowance goes up to 650,000 between husband and wife. So husband has 325,000, wife has 325,000, and combined together they make 650,000. That's if you're married with no children. If you are married with children, then your allowance goes up even more. It goes up to £1 million between husband and wife. So £500,000 for husband, £500,000 for wife. Okay. If the value of the estate is above those thresholds, the bit that is above is taxed at 40%. So that's quite a high rate. It's a very high rate. So people sometimes engage on what we call lifetime tax planning. They do things within their lifetime to reduce the value of their estate, which means that when they die, their families don't have to pay as much tax. So if your estate is above those thresholds, you need to be thinking about getting proper advice as to what you can do to make sure that your family pays as little tax as possible after you pass away. And the key here, the connection with the wills, is that these allowances of 325,000, 650,000 and £1 million, they're not given automatically. If your wills are drafted incorrectly, you could lose the allowance. The wills have to be drafted in a particular way in order to make sure that you get that allowance. I had a very sad situation not very long ago where a family within our community came to me and the wills were not drafted properly. The parents had passed away. The wills were not drafted properly. Not only were they not in accordance with Sharia, they didn't take into account any of this. So the family had to end up paying almost £60,000 in tax that could have been avoided entirely had the wills been drafted properly. So that was a huge lesson, that you really need to think about this properly when you come to do your wills. The person drafting it has to have an understanding of the tax system, and all of the issues that come with it. So I just wanted to touch on that very briefly, because unfortunately it's not something that is well documented or well talked about within our community. So I just wanted to bring that to your attention. It's a very complicated area, and I have simplified it hugely today. But if anybody wants any further information on that, please let me know. So for wills, I'm going to sort of end here, and the few takeaway points that I want to leave is that most people, especially people whose estate is above those thresholds that I mentioned before, they will require professional advice. You know, if you use a non-professional to draft your will, you can fall into all sorts of problems. As I said, you know, the example that I gave of a family who had engaged a non-professional to draft their will ended up with £70,000 to pay in tax that could have been avoided entirely. So using professionals that are qualified in the area, doesn't have to be me, there's many of us out there, you know, is always sensible when you're looking to protect your assets and your wealth. The second point that I want you to take away is, even though, you know, don't assume that your family are aware of what it is you intend to do. Try and have discussions with your families about what it is that you want to happen after you pass away. So there is no dispute, there is no ambiguity, there is no cause for anyone to come back and say that, you know, told me this or Daddy told me this. Have discussions with your family so everybody is clear as to what the intention is and what the path is going forward once you have passed away. And lastly, for wills, our aim is to leave behind khair. The will is the last document that you leave behind. It is the last document that your family and the people around you will remember you by. If you are unfair in it, if you are unjust in it, if you do something in there that is not appropriate, that is how the people that you leave behind will remember you. That's not how we want to be remembered. We want to be remembered in a way that is good. So our intention in leaving behind this will is to leave behind khair, to leave behind good, to make sure that our wealth is distributed in a way that our family benefits, in a way that we benefit in the akhirah, and to make sure that we are remembered well by our family and our friends. So that was just it for the will section. There's a lot more to cover, but as I said, the full presentation is about an hour long. If anybody wants that, I can let you have the YouTube link to that. The second part of today's presentation that I wanted to mention was lasting powers of attorney. And this is incredibly, incredibly important, especially in light of the current pandemic, where people are falling ill, people are sadly being, you know, on ventilators for, you know, extended periods of time. These have become so much more important. So the obvious question that we need to address is, what are they? So a lasting power of attorney, or what we call an LPA for short, is a legal document that allows you to choose people that you trust to look after you if you ever fall unwell. It allows them to step into your shoes and look after you. The difference between the will and the power of attorney is that the will only comes into effect if you remember when I die. So long as I'm alive, the will has no effect whatsoever. The lasting power of attorney, however, is used to look after me while I'm still alive. So I could be alive and I could be struck with an illness. I could be struck with a disability. And that lasting power of attorney is the document that my family will need in order to look after me properly. Now, one thing that I've put here is, what is incapacity? So incapacity is anything that affects your ability to make decisions. So incapacity can come because of age. So illness, Parkinson's, Alzheimer's, these are diseases, sadly, that we're seeing on the rise in our community. They impair a person's ability to think. Or accident. You know, we are not invincible. We could go out and be involved in a car accident or a bus accident or a train accident, and that could affect our ability to make decisions. I had a very sad case many years back that, you know, people who are young, you know, they don't think that they need these documents. I had a very sad case a few years ago where there was a young man, barely 25, 26 years old, caught in a motorcycle accident. He had inherited a lot of money from his grandmother when she had passed away. He was in a motorcycle accident. He was hit on the head. He had a head injury. He lost the ability, you know, he was disabled, became a paraplegic. His family didn't have a power of attorney, because why would he think of putting in a power of attorney when he was only 25? So this just goes to show that incapacity can hit us at any age and at any time. It's as important for the young as it is for the elderly. So these documents are important because, again, as with the will, they give you control. They give you the ability to decide who looks after your affairs for you. And as I said, in light of COVID-19, when we are seeing people unwell for extended periods of time, we are seeing people, let's say, sadly, on ventilators for extended periods of time, life around them continues. There are still business transactions that need to be done, still money that needs to be drawn, things to carry on. So businesses still need to carry. So if you do not have the power of attorney in place, there is nobody there that can manage that for you whilst you're recovering or whilst you're unwell. The lasting power of attorney dies with you. So when you die, the power ends. And that is when the will comes into effect. So the lasting power of attorney can only be used whilst you are alive. Okay? Now, some key terms that I will be using for the next few slides is donor and attorney. Donor is the person that gives the lasting power of attorney, the person that makes the lasting power of attorney. And the attorney is the person that they choose to look after their affairs for them. Now, in this country, we have two types of lasting powers of attorney, one for financial and one for health. Most people put both of them in place. You don't have to put both of them in place, but most people put both of them in place because it covers everything. So what sort of things does the financial power of attorney cover? So if you are unwell, it allows your attorney to look after your home. They can sell your home on your behalf. If, for example, as we have seen, sometimes when people become elderly, when people become unwell, they may need to go into some sort of residential care. The house may need to be sold to pay for that care. Now, the lasting power of attorney gives the attorney the ability to sell that property and to release the cash. It allows them to look after investments. It allows them to look after shares. It allows them to write checks, look after bank accounts, claim any state benefits. And it also allows them to make small gifts from your possession. So if you are in the habit of giving, a few, money to your grandchildren or to your nieces and nephews on Eid or birthdays, small amounts, I'm not talking large amounts, it allows them to continue that on your behalf, in your spirit. And again, also to make donations to charities on your behalf as well. So these are just some of the things that the financial power of attorney covers. The health power of attorney covers things such as where you should live. So for example, if you do have to go into residential care, the health power of attorney gives them the ability to choose the home that is the most suitable for you. It gives them the ability to have an input within your care. Many care these days do not speak or correspond with the family if there is no health power of attorney. So if you want your family to have the ability to have an input into your care package, it's useful to think about getting one of these. One of the most important things that the health and medical or the health and care power of attorney covers is the items that I've put in bold at the end. It allows your attorney, so the people that you have chosen, to make decisions about medical treatment when you cannot make that decision yourself because you're unwell. And in particular, I mean life-sustaining treatment. So life-sustaining treatment is anything that is needed to keep you alive, such as drugs, resuscitation procedures such as ventilators, artificial hydration, operations, organ transplants. If you have a power of attorney in place and you have given your family the ability to make these decisions of this nature for you, if you are unwell and you cannot communicate with your doctors to make that decision, your family, using the power of attorney, can make that decision for you in a way that is in accordance with the Sharia. So for example, our fiqh does not allow us to, artificially end somebody's life. We are instructed to prolong life for as much as possible, even if there is no hope. We're not allowed to switch off ventilators. We're not allowed to switch off life support machines. This lasting power of attorney gives your family the control and allows them to do that and say to the doctors, no. This power of attorney has given me, the attorney, as the family member, the authority to make these decisions, and I am going to use this power of attorney to make these decisions that is in the best interest of my family member. How do you make an LPA? Now, these are government forms, so they're readily available on the internet, and I've put the website there for anybody who wants to go and have a look at them. We usually find the forms can be quite complicated, so people usually come to professionals to get them done. But you can do them yourself. One important point is that as with the will, when you make the power of attorney, you must have mental capacity. You must understand the extent of the power that you are giving away to somebody else. You must understand what this person can do under the financial power of attorney. You must understand what this person can do under the health power of attorney. In order to make sure you have mental capacity, whenever you sign a lasting power of attorney, it has to be signed by somebody called a certificate provider. That is usually your GP or your solicitor. On the day that you sign the power of attorney, the GP or the solicitor also has to sign it, and they have to confirm that they have been through the document with you, you understand it, and that you have not been placed under any pressure to make that document. The donor, the certificate provider, and the attorney all need to sign the document. And once they have signed it, it has to be registered with a government body called the Office of the Public Guardian. Only when the power of attorney is registered can it be used. So there's no good in you creating a power of attorney and putting it under your pillow and forgetting about it. That does no good whatsoever. It has to be registered with the court, with the Office of the Public Guardian, before your family can use it. So there is a whole process to go through. You have to make the power of attorney, you have to draft it, you have to sign it, and then it has to be registered before it can be used. Now, this is a question I get often. What happens if I lose capacity? What happens if I am struck with an illness or a disease and I can't make decisions for myself and I don't have a power of attorney in place? I haven't gone through this process. What do I do then? Now, that's a very hard situation, because in that situation, somebody around you will have to make an application to the court for what is known as a deputyship order. Now, anyone around you can apply. Now, that person could be somebody you may not want to look after your affairs, which is why, as I said, the power of attorney is important, because it gives you control. It gives you the ability to choose who looks after you. With a deputyship order, anybody around you can apply. And I'm not going to go into the details, but if you don't have a power of attorney and you have to go through this court process, it is much longer, it is much more expensive, and the court asks many more questions than it does if there was a power of attorney in place. So, you know, the alternative is that it is best to get these documents in place. So just to end, why do I need an LPA? As I said, it gives you control to decide who makes decisions about your money, to control who makes decisions about your health in a situation where you cannot make that decision for yourself because you are unwell. And again, I just want to stress on the importance of professional advice. When we speak to clients and we go through these documents, we go through them in great detail. So it's not just we go to the form, we download it, we sit down, we have a conversation with them, we make sure they're choosing the right people that are around them, and we go through the whole process with them. So the point of the will and the point of the power of attorney is, as I've said here at the bottom, to take control of your life. It puts you in the driving seat. If you do not have these documents in place, other people around you can start to control what happens to you. And you don't want that. This gives you the ability to make your own decisions. I'm going to end there because I think we're running out of time. But as I said, that was a very, very quick tour through the position on wills and powers of attorney. Inshallah, as I said, the full presentations are available online. So if anybody does want them, we can make them available. So I'll stop there. I don't know if we have time for questions or not, Zinadanti, if people have.
No, I